we started the day with that defense of the rule of law, that principled resignation in protest from the Navy Secretary. We've now ended the day tonight, at least I think the day's over, with a clarion ruling basically along the same lines from a federal judge. Federal district court judge in Washington, D.C., who has been hearing the case of whether or not the president is within his rights to simply tell high-level administration officials that they should not testify to Congress even when they are subpoenaed to do so. The judge, in this case, Judge Ketanji Brown Jackson, tonight has ruled against the president and has ruled that in this specific instance, the official that the president has instructed to defy the subpoena, former White House counsel Don McGahn, the judge says Don McGahn must comply with that subpoena and he must turn up to Congress to testify. And this is a long ruling tonight. But it's interesting. It seems to me like it is written with a broad audience in mind. Because it's not a super legalistic thing. It's not just a mechanistic order that McGahn has to show up and here's the precedents that lead to that and so forth. This is the kind of court order, the kind of judicial ruling that is, if this were an indictment, you'd call it a speaking indictment, right? This is a ruling that is designed to be read by people who are outside this case. This is a ruling, I think, in the specific that is designed to remind us all what kind of government the Constitution spells out for us and why, when all else fails, we should be able to count on the judiciary, the court system, the rule of law to protect the Constitution, to make sure that the law is upheld, to make sure that nobody is above the law. In this case, the judge explicitly spells out that you should be able to count on the courts in cases like this to block the president from assuming powers for himself that Judge Jackson describes not only as monarchical, but tyrannical. She also repeatedly gives the Justice Department a big, strong brushback for their defense of the president's position in this case. She's just scalding about the Justice Department, about the position they took here defending President Trump, but also how they took it. Quote, when DOJ insists that presidents can lawfully prevent their senior-level aides from responding to compelled congressional process, and that neither the federal courts nor Congress has the power to do anything about it, the Justice Department promotes a conception of separation of powers principles that gets these constitutional commands exactly backwards. In reality, it is a core tenet of this nation's founding that the powers of a monarch must be split between the branches of government to prevent tyranny. Thus, when presented with a case or controversy, it's the judiciary's duty under the Constitution to interpret the law and to declare government overreaches unlawful. Similarly, the House of Representatives has the constitutionally vested responsibility to conduct investigations of suspected abuses of power within the government and to act to curb those improprieties if required. Accordingly, the Justice Department's conceptual claim to unreviewable absolute testimonial immunity, essentially that the Constitution's scheme countenances unassailable executive branch authority, that claim from the Justice Department is baseless. And as such, it cannot be sustained. Quote, DOJ says the president has the authority to make unilateral determinations regarding whether he and his senior-level aides will respond to or defy the subpoenas that authorized House committees issued during constitutionally authorized investigations of potential wrongdoing within his administration. At that point, Judge Jackson diverts briefly to insert a footnote, I kid you not, that references George Orwell. You can tell she's sort of gearing up for something here. Quote, unfortunately for DOJ, these contentions about the relative power of the federal courts, congressional committees, and the president distort established separation of powers principles beyond all recognition. The arguments that the Justice Department advances to support its claim of testimonial immunity for senior-level presidential aides transgress core constitutional truths. Right? We're putting Orwell in the footnotes. We are transgressing core constitutional truths. We are taking the Justice Department to the woodshed. I mean, at this point, she's only 39 pages into like a 120-page ruling, but she's just getting warmed up. I mean, look at this line. What is missing from the Constitution's framework is the president's purported power to kneecap House investigations of executive branch operations by demanding that his senior-level aides breach their legal duty to respond to compelled congressional process. I have never seen the word kneecap used as a verb in a federal court ruling before. What's missing from the Constitution's framework is the president's purported power to kneecap House investigations of executive branch operations. I have never seen kneecap used as a verb like that in a federal court ruling. I may have just been reading the wrong kinds of cases, but let me just read you. I'm just going to read you just a couple more lines here, and then I'm going to close with what I think is actually, I think, the most powerful part of the ruling. Judge Jackson says toward the end of this ruling tonight, quote, "The United States of America has a government of laws and not of men. The Constitution and federal law set the boundaries of what is acceptable conduct. However busy or essential a presidential aide might be, and whatever their proximity to sensitive domestic and national security projects, the president does not have the power to excuse him or her from taking an action that the law requires." Stated simply, Judge Jackson says, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. This means that they do not have subjects bound by loyalty or blood whose destiny they are entitled to control. Rather, in this land of liberty, it is indisputable that current and former employees of the White House work for the people of the United States and that they take an oath to protect and defend the Constitution of the United States. So like I said, this is the judge's ruling equivalent of a speaking indictment, right? This is a history lesson and a message to the public. But I just want to read you just one last piece of this, because this is the Don McGahn case, which is being decided here by this judge, right? The ruling says, bottom line, that Don McGahn has to testify, that Trump can't tell Don McGahn to defy the subpoena to testify. But this case did not come up in the context of the current impeachment proceedings against President Trump, right? You will remember that Don McGahn, then White House counsel, was subpoenaed to testify to Congress, not because of the current impeachment, but because of the Mueller investigation. Remember, Don McGahn was like the key witness to 10 different instances of potential obstruction of justice that were laid out in great detail in Mueller's report. Don McGahn was cited more than any other witness in that report. But even though that was the context in which this case was initially brought, the case is being settled now. This ruling is arriving now tonight, of course, while impeachment proceedings are underway, and while congressional oversight of this president is therefore at its most serious and most consequential point yet. And so this is just the last bit of this that I want you to hear. Listen to how Judge Jackson sort of situates us here in that moment, in the importance of this moment for the rule of law, for the fate of the republic. She says, quote, "When a committee of Congress seeks testimony and records by issuing a valid subpoena in the context of a duly authorized investigation, it has the Constitution's blessing. Ultimately, the committee is acting not in its own interest, but for the benefit of the people of the United States. If there is fraud or abuse or waste or corruption in the federal government, it is the constitutional duty of Congress to find the facts and, as necessary, take corrective action. Conducting investigations is the means that Congress uses to carry out that constitutional obligation. Thus, blatant defiance of Congress's centuries-old power to compel the performance of witnesses is not an abstract injury, nor is it a mere banal insult to our democracy. It is an affront to the mechanism for curbing abuses of power that the framers carefully crafted for our protection. It is hard to imagine a more significant wound than such alleged interference with Congress's ability to detect and deter abuses of power within the executive branch for the protection of the people of the United States." And so Don McGahn and other senior White House officials who have been told to defy congressional subpoenas by the president, according to this judge's ruling, Don McGahn and similarly situated White House officials, they are not bound by the president's instruction when he tells them don't go. They instead are bound by the subpoena, and they must go. They must go to Congress, and they must testify. Now, in response to this ruling tonight, Don McGahn's lawyer said this. He said, quote, "Don McGahn will comply with Judge Jackson's decision unless it is stayed pending appeal." And at the time I got on the air tonight, the decision had not yet been stayed pending appeal, but everybody's expecting that it likely will be, while the Trump White House and the Justice Department under William Barr try to drag this out as long as possible and keep appealing as far as they can. So we'll see how that affects the ongoing investigations and the impeachment proceedings on Capitol Hill and who has to testify despite Trump telling them not to. I mean, we don't know exactly the time frame on which this will ultimately be resolved if, as expected, the government appeals it to a higher court. We also don't know whether any of the White House officials who are currently refusing to testify in the impeachment proceedings might have been waiting for a court ruling like this to give them some cover. Right? This is a court order that says you have to follow these subpoenas. You have to obey these subpoenas. The president telling you not to is not actually legally kosher. The president does have the right to tell you to defy a subpoena for no reason. If there are any White House officials who have been defying subpoenas on the president's order, and those White House officials, in fact, in their secret heart of hearts, might actually want to testify rather than having to, continue to sit there silently while everybody else tries to blame stuff on you and you're not allowed to defend yourself, just speaking hypothetically, Mulvaney. But we don't know whether there are any of these White House officials who might have been waiting for a ruling like this to make a change, to make a decision in terms of whether or not they are going to obey subpoenas or whether they're going to continue to defy them.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.